and they want to be able to call the military into the streets and seize American citizens and hold them without due process. You know, Judge Forrest, in her 112-page opinion, when she issued a ruling, brought up the issue of the 110,000 Japanese Americans who were detained during World War II and stripped of due process, as this provision within the NDAA essentially opens the door for that possibility.
All rise. Court will be meeting.
All right, please be seated. This is the matter of Clarence Morawaki versus Richard Renierson, cause number 12-17. And I see that we have the petitioner present, and I believe the respondent is present with counsel. Is that correct?
That is correct, Your Honor.
All right. We will have a respondent information form for your client to fill out. Did you have a chance to get that for them? Okay. All right, and I did receive the briefing that was prepared by each of the parties and have had a chance to read that in its entirety. So, did you receive a copy of Mr. Morawaki's paperwork that he submitted?
I received it from the court clerk. I did not receive anything from the petitioner. Similarly, I received an additional document from the court clerk about 10 minutes ago.
This 2-page document?
Yes, Your Honor.
Okay. And did you receive a copy of the respondent's brief?
The stay for, yes, I did.
Requesting the stay?
Yeah.
Okay. All right, so we are here today for the full order hearing. This case was continued once one counsel came on, as is typical to do when an attorney joins the case, to give him time to prepare. Since the respondent is requesting a stay in the matter, I will hear from you first regarding your request for a stay. I will say that that's not uncommon when somebody has pending criminal charges. The court typically does give time and extends the temporary order. It's so that you can determine whether or not charges are going to be filed in the criminal court, and then we'll, set the full hearing out. And I understand all the reasons why, so I'm not sure I need a lot of legal argument on it. But if there's anything that you wanted to say regarding that, I will hear from you.
I'd just like to give a little bit of brief background. So we filed a public document disclosure request right either a couple days before or right after we were hired. On this case, my client actually filed it, and we didn't get a response from our request until I believe it was late Thursday of not 2 days ago, or excuse me, last Thursday, but the week before.
Disclosure of? The
response of our disclosure request, specifically pertaining to the police report regarding this case. So we were.
So you requested from the police department a copy of the police report.
So we requested it right around the time of our initial continuance request, and unfortunately the response from the police department was not especially prompt, and so we didn't get word back until about 8 days ago, Your Honor. And so at which time I reached out to the county prosecutor's office to see what's going on. Has a decision been made, or what's happening? And the prosecutor hasn't even looked at the file yet. I spoke to him, and he said he was hoping he was going to get a chance to look at it last Friday, so approximately 2 days ago. But I haven't heard back from him yet. I did exchange a couple quick emails to him just saying, hey, let me know if you made a decision either way, and what's your timeline like. And so that's the extent.
Did he give you a timeline?
He said he was hoping he could get to it around last Friday, but I haven't heard back from him as of Friday, or rather this morning. So I don't know what exactly his timeline is going to be. I'm hoping we'll get a response either way in the next week or so. But then obviously the issue is if he thinks there is sufficient facts to warrant proceeding forward, then we would be asking for a lengthier stay for that to play out. But at this time, I don't think a lengthy stay is maybe the way to go, simply because there's I think a relatively large chance that charges will not be filed. But that's basically kind of the status of things with the county at this time.
Okay, thank you. And anything else that you wanted to add, or is that it?
I filed the briefing, and so I think that summarizes basically our position and why we do need to stay. We were prepared to move forward today until we found out about the possibility of charges, and so that's the full reason why the stay has been requested. But once we know that there are no charges, then we're ready to proceed forward as quickly as possible.
All right. And Mr. Morawaki, do you have a response regarding the stay request?
Sure. I don't think it's necessary, and it's unwarranted. As one friend of mine who's counsel said, that this would be an unprecedented stay for the situations that's civil versus criminal, and as the respondent's attorney just admitted, there isn't any investigation going on right now. The prosecutors have not done any charges, and it's the equivalent of saying the judicial system can't walk and chew gum at the same time. I'm asking for civilian personal protection on a civil case, of which the cyberstalking, and I think your temporary order was correct. It is clear that Mr. Reinerson has been stalking me and has been violating, and he stepped over the line. So just asking for a personal order. Secondly, the stay wouldn't be necessary because I've gone through this twice now. I went through March 27th when we were supposed to have the first hearing. He did get a continuance. Now we're at a second time. I can't keep living my life going toward the next milestone for the next time I have to relive this. The stuff's here. I have people here who are willing to testify what Mr. Reinerson's behavior was beyond my own personal contact. And so the decision could be made now, and there's no need for it. And secondly, in the order, it tries to plead the Fifth Amendment as some sort of tool that can be used to stop proceedings. And as
Well, it wouldn't necessarily stop the proceedings. It would still allow for the temporary order to continue.
But I can't live with a temporary order, Your Honor. I really want a permanent order. I can't keep coming up. The anxiety I've been going through and the fear I have of this person, I'm leading up to these dates. I come to the day, and if I have a stay, when is that date? Do I have to live with this for a year, for 6 months? How is that relief to me? I've done everything by the law, and I have people who have also will testify on this behavior. A decision can be made on the protection order, and it can go on. It has nothing to do with the criminal proceeding. If the prosecutor moves forward on that, then that's another topic for the respondents to deal with. But it has nothing to do for my personal protection, and that there's no reason why the stay has to be in place, because my relief has to be now.
Okay, thank you. And now I understand the parties' positions regarding the stay, and I have had a chance to also read your request for surrender of firearms, and I am going to consider that today. And so I don't know that you need to add anything additional, but if you'd like to say anything additional regarding your request for him to surrender his firearms as part of the temporary order and to continue, or as part of your request today, I'll go ahead and hear from you, and I'll hear any response that defense counsel has regarding that today.
So for the
For the
permanent order or for the weapons issue?
So if the court were to grant the request for a stay and continue the temporary order, you are asking for what I understand is two things: to add a surrender of weapons and concealed weapons permit, and to expand the feet condition in the order to be 500 feet.
Correct.
And so I'd like to hear from you regarding those requests now, and have the
Certainly.
attorney be able to respond to that portion of the request
Right.
today before I make my decision.
Sure. Well, on the second one, when I filed for the temporary protection order, I just picked a number. I didn't know what an appropriate distance was, so I just wrote down 100 feet. Upon learning from other counsel and other judges, typically, and this court has been typically granted 500 feet. That's an unusual distance, and so I would want that to be the standard that's been given to other protection orders and stalking orders and such. Secondly, where I live at Winslow Green. I'm sure you're familiar with that area. It's right above Bainbridge Bakers, and I overlook the green, and I want to be able to sit on my deck anytime and not worry that Mr. Reinierson is out on the street looking at me, stalking at me, and 500 feet would allow me to look over the green and toward Cafe Nola and know I'm never going to be stalked. His evidence of his spy car, anti-cop car with all the surveillance information in it, indicates that this individual has used this kind of technology to record events, and there's no reason for me to believe that he may be doing that also in a car across the street or just in his person. So I need that 500-foot barrier.
He's an Air Force pilot who served in Iraq and Afghanistan. Now he's based in Texas, where he found he had to pass through checkpoints all the time.
There's no way to leave the border town without going through a checkpoint.
The checkpoint he had to pass through most often is 67 miles from the border.
I started to feel like I was asking permission to leave that town. I'm just traveling in the United States. I haven't crossed any borders, and I didn't really like that feeling.
So he installed cameras in his car.
Because I wanted to be able to prove the truth of events.
It is not a hindrance. I believe he should have his freedom, but there's plenty of ways for Mr. Reinierson to go home, other routes he can take to go to his residence. So it's really not a hindrance to him. It's really allowing me to have a protection of my life. About the guns, this is something that has frightened me. I've been having a lot of sleepless nights and literal nightmares. As I wrote in the piece, as I wrote in my statement to you, Your Honor, the comments that he had been officially reprimanded as an officer about boasting about killing people to law enforcement officials is just stunning. And as they said, it was abysmal and shocking. And as you probably know, in the military, letters of reprimand are strong documents. You get to a point where a person really has to be disciplined and watch carefully about their behavior, and this was behavior certainly unbecoming an officer according to his own officials. So, and I come from a family of military folks, as I wrote in my piece, and none of them, including my families who are veterans and friends of mine who are in the American Legion and others, who have actually seen battlefield contact, not as a pilot like his, and it's all, being a pilot is a demanding and frightening job, but it's different when you have face-to-face contact. And nobody I've ever met ever bragged about killing people. Not one of them. And that's frightening to me. And his statements about saying when he lost his court judgment against the Court of Appeals, he has this whole article about I've killed people more worthy than these two judges, and then calling them the tapeworms of society and killing America from within. This is frightening, strange stuff. I've never had to deal with this in my own personal life. And so I'm very concerned about the weapons, and especially the car. If he is willing to go to the effort to bulletproof his glass and put body armor in his car and smoke screens and then electrify door handles, as I said in my statement, that is a premeditated force of action thing that's meant to injure, harm, or do worse to an individual. And he's doing it as Veterans Against Police Abuse, his obsession about being targeted by law enforcement.
So this is electrified.
Yeah.
That does feel weird.
Yeah.
That's awesome. So if a cop tries to, like, open the door.
Yeah, if he's trying to jimmy.
Are you reading the Constitution?
Yeah.
Open the door, and then you just get this really uncomfortable shock. As soon as
You might just keep him to stay away from the door handles or something.
That's awesome. That's incredible. Can you get into the smoke screen?
I never plan on using the smoke screen. It's really just a toy for, to make the car more interesting, to get people talking about it, so that I can direct their attention to the cameras, because the cameras are what matter.
Yeah. And also the necessity to film police.
Exactly. You've got to be able to prove the truth of events. So the smoke screen's just a toy, but
well, Richard, from Veterans Against Police Abuse, he's an active serving military person, and he's been the subject of police abuse in the past. That's why he founded Veterans Against Police Abuse. They came together and they said, most police abuse happens in the car, so maybe we should focus on the car first, and then we can move on. So what would we want in a car? Well, first of all, you want cameras, right? You want microphones. Okay. And you want the information stored off the car. So they went ahead and they built this car, and it's a beautiful car. I saw it over at the Police Accountability Summit. Now, I'm not talking beauty as being, red with awesome wheels. It's very plain, kind of sporty looking, but the beauty in it is the protection it offers. And when I say protection, I'm really not talking about the protection of having bulletproof glass or, armor-plated doors and body panels and all that. And he said that's a little excessive, I know. But
Ranierson is the founder of Veterans Against Police Abuse, an organization dedicated to strengthening the constitutional guarantees for all Americans through public education, creative enterprise, and legislative reform. Were your experiences as a military veteran a factor in founding Veterans Against Police Abuse?
Certainly, the oath that I took to support and defend the Constitution against all enemies, foreign and domestic, that resonated with me. And it's not just because I took the oath, but more importantly, it's because I really value the oath. I'm not a doctor of history or anything along those lines, but I have read from the founders, and I have looked into world history, and I understand that liberty is not something that grows on trees. This is something very special that we have, at least the chance to have a country that recognizes our freedoms and our liberties, and that is something that I want to continue, because obviously I want to live in a free nation. I want my friends and my family to live in a free nation, and also because I want to honor the sacrifices of veterans that have come before us that have given so much to defend that liberty. And when I say veterans, I mean military veterans, but I also mean veterans of the civil rights movement. People like Martin Luther King and countless others who suffered fire hoses and death and beatings to advance the cause of liberty.
Now, tell us about the car. What kind of car is it? It's a Mitsubishi Eclipse. What are some of the features you've added? Tell us about it.
Okay. It's armored. It's bulletproof. That's kind of fancy. That's not something that we really push a whole lot. Most people aren't going to be able to just go pick up an armoring package for their vehicle. But it does make the vehicle interesting, and it allows us to talk about the surveillance systems that are inside. And those are the things that Americans can take and implement themselves.
No, I don't know if I've introduced Rick. He's from the Veterans Against Police Abuse. And there was quite a lively discussion on the Glock forum recently when some police officer found his video and obfuscated or altered the name of your organization and turned it into the Veterans Against Police, I believe it was. And man, some of the stuff that was said in that thread, I couldn't believe I was hearing police talking. Like children.
Yeah, it was really pretty irresponsible. Up until I had joined their forum to defend myself, these guys they didn't know anything about me except that I, was from a group, Veterans Against Police Abuse, and that I had put some defensive surveillance, camera systems in my car. And based on that alone, the language that came from these people, accusing me of being a nut job and a wacko and, the next movie theater, mass murderer, all kinds of stuff. And it's just kind of shocking. It's like they equate, you taking your life into your own hand by defending it, being a responsible American to look out for yourself and your family. It seems like they equate that to being crazy. As if to say that there are no police that lie, like that never happens, which of course we know isn't the case. It does happen, and it has devastating effects when it does. So I was a little shocked at the irresponsibility in the language.
Yeah, I was definitely taken back.
Okay. Now, Rick Ranierson has a spy car, and it's I'm not even sure I would call it that. I mean, it's kind of like, protect me from cops lying car. That's what it is. But and we have so much experience with this. And
if you wanted to mount it on there, you can get the interior of the car. My lawsuit against the Border Patrol, it's up on YouTube. You just Google military officer and Border Patrol. You'll see me in that video. That was, of course, with the older version of the ADR. So you can see it's really good. It does a really good job. The other thing with the ADR... So yeah, we're out here at the Police Accountability Summit, Peaceful Streets Project's putting on down in Austin, and we're just hearing from Rick, who founded Veterans Against Police Abuse. He outfitted his car with, I don't even know how many cameras he just went over, probably like 10 or 12 cameras, at least 6 audio recording places. It streams, it records to a DVR in the car as well. Lots of redundancies, and it's probably the best vehicle setup I've ever seen, so pretty awesome. I'll try to get another interview with him with a high-quality camera and chop that up, put it online. So be on the lookout, and more come from the Police Accountability Summit. Now, the surveillance, of course, is there mostly to protect myself against unlawful law enforcement agents. I've had 2 bad experiences. I have 2 lawsuits. I've seen a culture that I think is just absolutely rife with abuse, and we have a lot of challenges.
So I think Obviously, I'm not law enforcement, but I think, good law enforcement officers, and they are certainly out there, and we have to always remember that, they're going to have the same view that any good American will, which is that we need to do our jobs and protect the public as we're paid to do, while also preserving their liberties and protecting their liberties in accordance with the Constitution and in accordance with the law that they do. So I think the association thing, you can't judge an individual based on it. And it is a group, the military or the police, there are good cops and there are good military folks, and I don't think there's anything inherently wrong with being a public servant. Now, when they choose evidence suggests otherwise, then we should hold them accountable.
When you have oppressive laws, and when you have the government peering in everybody's bedroom or regulating what they eat or ingest in their body, when you have this pressure, it's going to make people, uncomfortable. And some people are going to lose their minds, unfortunately, like that guy who ran over the vehicles. I don't know his backstory, and, if it was about having a bag of pot, then I think it's unfortunate that, he's had problems with that. But that doesn't justify, of course, vandalizing pieces of public property. Violence or destruction, that's not the answer. And you're right, though, we do need to have a dialogue because we need people on both sides of the issue who are concerned with America, to figure this out, because we don't want the bad cops on their side making the situation worse because they don't value America, they don't value the rule of law, and we need people on our side, who are just regular, tax-paying citizens who, go off the deep end because they also don't value the rule of law. It's one thing to be wrong, it's another thing to do wrong because you were wronged, So,
Rick, if you wouldn't mind suggesting to our listeners, what are some basic thing or apps or anything like that or techniques for when you have an interaction with a police officer holding them accountable or filming it or things like that? Like what are any advice you would give?
And as far as advice goes, I would say know the law, don't break the law, and realize that if you do break the law, whether it's speeding or running a stoplight or whatever, and law enforcement gets in your world, well, that's what they're expected to do. So you got to realize, you got to have some humility and realize whether you like it or not. If you're breaking the law and they're doing their job, then that's the way it's supposed to work. So know the laws and then and don't break them. And then if it's the officer who's breaking the law, as happens all the time, then you got to be able to video record it and prove the truth of events.
If he is willing to do that kind of action, premeditated action, against an armed professional law enforcement person, I'm an unarmed private citizen. If he gets angry, of which there's also documented anger of him in the statement that I presented, and that he has been reprimanded officially by his superior officers for his anger, and his comments online, the incredible screeds that he goes through when he's blocked and banned from other sites. He's willing to write that down as his emotions at that time, and that's the stuff he's willing to put publicly online to people. I'm uncomfortable being this close right now. I don't know how else to articulate this to you, Your Honor. It's something I've never had to deal with. And so that's why I need relief from the court.
All right, thank you. Response?
Thank you, Your Honor. So first of all, the vast majority of what the petitioner is describing is simply cherry-picking small portions of a longer history and set of circumstances in my client's past. And we would like to certainly provide a lengthier, full explanation of everything. Unfortunately, the petitioner has submitted documents in 2 business days before the appearance today, which is contrary to the court rules of timely petition. And so we take issue with that because we have been unable to prepare a response to fully address all of these allegations, because he's talking about a lot of things that my client was validated by on appeal, and he might take one opinion on certain things, but half the population agrees with him on other things. And so it's difficult for me to have a full response to these small snippets without providing the court with the full explanation and documentation. And that's where we have an issue here, where we haven't been properly served, we haven't been given appropriate time in advance to provide that response. Additionally, everything that has just been described are all allegations that were made after the fact when he initially filed his protection order. All those things have nothing to do with the petitioner. He has not said a single thing that had any correlation to him. The only allegation of any type of physical stalking, if you will, is one Facebook post. That Facebook post was based off of an analogy that the petitioner wrote himself, and he responded to that analogy continually. When one of his friends...
Well, and I understand, and I mean, I think for the purposes of these types of hearings, he doesn't need to resuscitate every single thing that's in his written petition from before, because he knows the court has read it, and I have read everything in the file. So I understand what you're saying, and I'm not expecting you to provide full briefing. If you wanted to make a response to this before the court makes a decision, I'm open to hearing that. And this is not going to be... If I decide this, it's not going to be the full order. You will have additional time to respond in full.
And so point being is, there is not a single statement written or verbally made threatening. There's no conduct threatening, no behavior whatsoever that would indicate any type of threat or inkling of violence towards the petitioner here. The entirety of this request is based off of snippets over the past 8 years from my client, when he was having a legal fight with in the 5th District about being unconstitutionally stopped. As well as him being reprimanded for failing fighting against what he deemed an unconstitutional order, which he appealed and he won. He was validated on that. He was reinstated by the military with full accreditation. He filled out the remaining 5 years of his 20-year career, and he retired with honors. So, again, this goes to why we need to have a full explanation, because how the petitioner is casting my client is not accurate. That is a small snippet, but if we have an opportunity to fully respond and show the full context, I think it should be able to be seen that my client isn't a danger. He was willing to sacrifice a 15-year career so he would not harm a U.S. citizen. He went up against the might of the military, put his career on the line to protect a U.S. citizen. And the petitioner, if he's read the documents, he knows that. And so there is a distinct hypocrisy in claiming that he's a afraid of my client when my client is willing to sacrifice a 15-year career of somebody he doesn't even know because he feels that that would be a violation of that person's constitutional rights. So we do adamantly deny that a gun forfeiture at this time is warranted. We've seen nothing that would draw a nexus between the petitioner and my client supporting the claim that there's any concern for violence or anything physical in nature. Furthermore, the distance requirement already as it is now is actually causing problems for my client. The two, in fact, live very close to one another. The driveway from my client's property is less than 100 feet from the petitioner's residence. So,
now, I had been under the impression that either you or your client told my staff that he moved out off of Bainbridge Island.
He did at the time, yes.
But he's now back living there?
Well, not at the moment, but
okay.
The thing is he'd like to be living in his house. I mean, at a certain point, you can't be living in hotels for the rest of your life. Why did he, I mean, this court did not require him to move out of his house, correct? No, the problem is he cannot leave his house at either of the two ingress or egresses without coming within 100 feet of the petitioner's residence.
Okay.
That's the problem.
Well, let's talk a little bit more about that. And you're telling me that is why he moved out? Because there was no request to the court to modify the order or to make it so he could live in his home? He just moved out?
He felt that would be the safest thing to do because he did not want to have any accusations from the petitioner claiming that he's violated the conditions. And this is an issue because I received a call from a detective last week, and apparently he was contacted about some postings from last February with claims that my client was in violation. I had a conversation with the detective, pointed out what the temporary order said, and he agreed with me. And that was that. And so the issue now is my client was willing to sacrifice his inconvenience for the period of time between the last hearing and this one, but with an additional continuance, it's getting costly. But additionally, he's worried that any inadvertent proximity violation would result in another call to a police officer. My client fully understands and has no desire to have any communication with the petitioner, but the worry is inadvertent contact can result in a phone call, just as posts that were private from February resulted in a phone call to a detective.
All right, and so is this the Shepherd Way address? Does he own that property?
Yes, Your Honor.
I'm looking up the addresses on Google Maps. So that tells me that you don't come anywhere near his property at the Winslow Green. Mm-hmm. What I see, and you're welcome to look at this on my screen, counsel and Mr. Rocky. So this shows me that he's located at the dot right here, and he has to go out this way. This is where his property is. You can come up if you'd like to, and it's he can go this way or he can go this way. Mm-hmm. I'm not seeing that there's an issue. So you can tell me.
This is the respondent's wife. She's living in the residence as well.
Okay.
And I'm not familiar with this. And
so the issue is that we ordinarily walk to the ferry, and our development has a walking easement that goes right along the edge of Winslow Green, or we walk this walking path to Madison. Uh-huh. If we drive, it's true. If we could go like this, but if we're going to go to the ferry, here we're within 100 feet also. Presumably we could drive down.
In the city hall right here?
Yes, and that's, I believe, within 100 feet. I do know that the residents...
And then can't you just walk right through here and over here?
I guess I had not considered that walking path. I was just looking at what we ordinarily do, which is come down the easement to Winslow or over to Madison into Winslow, and besides excluding us from Winslow Green, you know, all of these businesses that we usually go to are within that distance, and of course within 500 feet, our actual residence is within 500 feet. If you do like this, that's 300 feet.
It's 300 feet.
Yes, Your Honor.
And this isn't going to allow me to do a bird's eye measurement of.
We do have bird's eye measurements, Your Honor.
Okay. And Diane, you want to turn that thing on, and you can put it up underneath there. Looks like it's turning on. I think you have to turn the TV on, though. Maybe it knows that the TV isn't on. And then the side little gear can zoom in on it. So what I'm seeing is a measurement that reaches the edge of Winslow Green on the back side of the building by Bainbridge Bakers, and then it says 303 feet between the chosen locations. Is that what you're trying to present?
So this here is, that's the respondent's residence, and then this is, to our knowledge, where the petitioner is residing, correct?
I can help you on that.
Well, I think that that's the very edge of the property line, but not maybe the specific home.
Right. But if we're going from residence to residence, shouldn't it be at least that? I mean, he could make the argument of the property line is the edge of his property line, which would be, you know, way toward the bottom of where that construction thing is. So if you're going to do this from residence to residence, should we not be consistent?
Well, I know it's a imperfect rendering, but it's helpful to the court in terms of understanding roughly where people lie towards one another.
Right.
Okay, so thank you. Can we file stamp that and put it in the file? All right, so here is what the court is going to do regarding the motions here. Regarding the requests for the stay, I understand Mr. Moriwaki's position on this and the frustrations that he feels about this situation. I can see that there's a courtroom full of people here who've made the effort to come. I believe as nodding along, supporting Mr. Moriwaki. However, I also have to take into consideration the defendant's constitutional issues in responding to this petition. Although he has hired counsel and counsel can assist him, it's not quite the same when pending law violations may be filed against him. It sounds like that should be something that occurs in the short term. And so I am going to grant the request for the stay, continuing the temporary order and setting up a schedule that I hope will be less imposing on the petitioner. What I have done in the past when I have more serious criminal charges that are possibly pending is continue the temporary order and set basically a status conference over the telephone, so it's not the full hearing, but it's just a date that where we have you call in, your client's presence is waived, we talk about what's going on with the charges, are you ready to go forward, and that we only set a date, a full order date where people need to be here in court when we know that everybody's really ready to go forward and there's not going to be any problems or continuances. So for the main reason that we want to, if there are charges filed, that's pretty standard that those would have to be resolved before we could have a civil hearing. And this is not something that is only done by this court. This happens in lots of other courts, and so I understand the frustration, but the court is going to grant that. Based on the petition for, and we'll talk about dates in a little bit. Based on the petition and request for the amendments to the order, this is what the court's going to do. I find that based on the information that's presented, I believe that the respondent can live in his home, which he owns, and stay within 300 feet of the person's residence.
Your Honor, may I split the difference there, because counsel, or the respondent's counsel, deliberately went to the very edge of the parking lot, which is way to the back. I'll go 400. That would not be where my residence would be, on according to his own map. So,
I understand that, but I need to stay within this, and I'm going to make some recommendations regarding their travel. So you're to stay not come within 300 feet of his residence, workplace, or any public meetings where he's present at.
may I also make an addition to the temporary?
If you can just stop, let me make my ruling, and then we'll talk some more, okay? So based on what I see in the map here, I think that the respondent can easily live in his home and travel a different route. You don't have to go past the Winslow Green, and nor should you. There are different ways for you to travel to the ferry, and you're going to have to take those ways. There's some limitations placed on you based on this order, and the expectation is that you should not be visiting the Winslow Green. You may not be able to go to some of the shops in downtown Winslow because of this order, and that's just going to be how it's going to be for the duration of this particular order. There are other places to shop. There are other places to get things. We all purchase a lot of things on the internet these days, and that's how it's going to have to be. And you should not be giving yourself any reason to make Mr. Moriwaki concerned about your location and your behavior, either directly or through third parties. So that's going to be the court's order regarding the fee provision at this time. The court will revisit this at the full order hearing, and so the parties can bring more additional evidence if you want to have the 500 feet provision, and we will revisit that. Regarding the weapons surrender request, the court reviews for purposes of the weapon surrender RCW 941-800, and that was amended in 2014 to allow courts additional ability to require respondents in protection orders to surrender their firearms. Specifically, I'm looking at subsection 4, which says the court may order temporary surrender of a firearm or dangerous weapon without notice to the other party if it finds, on the basis of the moving affidavit or other evidence, that irreparable injury could result if an order is not issued for the time until the time for response has elapsed. So to address your discovery issue and the court rule issue, the court finds that I don't have to require strict adherence to that rule at this time, because this is what's considered a temporary order. The court can do this ex parte and doesn't have to provide response for an initial order. And I am going to give you a chance to respond to that at the full order, but I am going to grant his request. According to subsection 5, the court does find that based on the defendant's behavior and directed targeting of the petitioner and his prior internet behavior targeting others and his behavior in the internet world, which I think is relevant here, that he does present a serious and imminent threat to public health or safety and the health and safety of Mr. Moriwaki. I'm concerned about the allegations here, I think that the fear that he has is very reasonable. They're operating in this sort of internet world where they don't even really know each other, and yet the allegations here are that the respondent has directed a great deal of negative energy towards this person who he does not know very well, and has done so in the past to others, and when things have not gone his way or he's been banned, there's been even more negative energy directed, and I find that possession of a firearm under these circumstances is extremely concerning to the court. And so as a temporary measure at this time, you are going to be required to surrender your firearms, you're going to be required to surrender your concealed weapons permit, and that's the temporary order of the court. You're going to need to do so immediately, and I'd like you to do so to the Bainbridge Island Police Department and then file proof that you've surrendered those firearms with the court. I'm going to set a review hearing on May 1st, which is waived if you file proof that you've surrendered your firearms and concealed weapons permit to the police department. So you don't need to appear here or have your counsel appear here as long as I have proof of those things in the file. So that is the temporary order of this court until our next court hearing. I'm going to set a status hearing. The expectation would be as long as we're doing status hearings, these orders will be continued until we get to the point where we have a full order hearing. And then everybody will have an opportunity to present whatever evidence they would like to present and argue regarding whether or not the court should grant the full order and grant a lengthier order regarding surrender of firearms. Does that make sense? Any questions about my order? Okay. And so I would like to know, before your client leaves, how many firearms is your client going to be surrendering, and what is his plan to surrender those?
There are firearms that are owned jointly between him and his wife. And
He has to surrender them.
I understand. I'm just letting the court know. So, sounds like between the two, there's a total of 4.
4. All right. So, one of the things that you need to understand is that you are prohibited from possessing firearms as well as having to turn these in. And if you were to be in technical possession of the firearm, you could be charged with a felony. So it's very important that you understand the terms of this order and that you abide by them. So if there's any questions that you have, you need to discuss those with your attorney. Do you understand? Yes? You're nodding yes? Okay. I'm going to give you some paperwork that explains how it is that you turn your weapons in. You need to contact the police department to let them know that this is your plan. Make sure that you leave all firearms in the vehicle and that you follow any directions that they have regarding surrendering the firearms. Okay? All right, so the order continues in the same way that it did before. And so all the terms are the same. The only changes that the court made was that the distance amount changed to 300 feet and also included public events where the petitioner may be present at.
May I ask for another clarification if possible?
Yes.
Under the Facebook pages thing, we're having some issue there with the respondent. The police did call. He's got a web page that he is the creator of, this World War III Japanese American internment page.
Mm-hmm.
He still has some memes up there of me, which would be in violation of the TPO because it's his, but he claims to the police that they went from closed to private. What I gave to you and what was with the respondent's attorney today are screenshots I just took today of his page. Mr. Reinerson closed the page on March 15th, and yet the very next day, him and his alternative identity, Richard Lee, did remove it after the date. So he was removing items among the page that did include my image and or a meme of me or a comment of me, and yet further down there's a date of February 9th, and there's another one of February 21st, and there's many, many more on the second page that are still on this page that is not in response to the temporary protection order. And this, if I will draw your attention to it once again, the first page shows that he did remove a meme after he closed it to make it private. He closed it on March 15th, and it says on March 16th, the meme under his wife's name says we removed this under the court order. So they removed stuff after he closed it. The argument that it went private is just ridiculous.
I'm confused. So they made it closed, and then but there's still old posts that weren't removed within the closed group. Is that what you're?
He was removing. He moved stuff.
How did you obtain this?
It's just on the internet right now. I just picked it up this morning.
They're still public.
Yeah.
There are still posts that are public. I see.
I wrote it up there. Just screen grabbed it today before I came to court.
Okay.
Your Honor, and if I can approach. I was in contact with the detective, and I was emailing back and forth, and I can provide the court with our email exchange, but I can read it in part to the court. Specifically, after our first conversation, I asked the detective to send me the links of what was being claimed to be public, because obviously I don't know what he's referring to. So he sent me a link, and when I click on like myself, it goes to this World War III Facebook page.
Mm-hmm.
It's set to private. It's a closed group. I cannot access any of the links.
Mhm.
So I asked the officer, the detective, can you please provide me as to what exactly you're referring to, because the link you have provided to me is a closed group. His response is, I think you're right. You have to be a member to see the postings. There isn't a direct link that would bypass being able to view the group postings without being approved by an administrator. And my response to him is, well, if there is some post that you're able to access publicly, we're not aware of it. And if you are aware of some way to circumvent the private listing, please let me know, and then we will address that. And that was it. And
Let me ask you a question. When you went to Facebook, were you logged on as a member of Facebook?
I did it both ways.
And nothing would show?
No. Well, so first of all, I'm not a member of this group. So
I know that,
okay.
but are you a member of Facebook
Yes.
when you logged on to Facebook?
Yes, I tried it with my own personal account as well as public, and I wasn't able. So based off of the link that the detective gave me, it went to a private group, a closed group, and I wasn't able to access anything. I then offered to him, I asked him actually for clarification, saying, is there a link out there that actually can somehow circumvent this that I'm unaware of? Because what you've provided to me doesn't work.
Well, I guess is your position that your client can say whatever he wants about Mr. Moriwaki as long as it's in a closed group? And it's not a violation of this order?
Based off of the temporary protection order, that was my understanding.
Mm-hmm.
But first of all, he hasn't been making any posts, period, since we're dealing with an old post beforehand. So
But it continues.
Well, he hasn't been writing anything more.
But it continues. He hasn't taken it down. That's the issue.
Well, he made it to private, yes.
Hasn't taken it down.
No, he hasn't taken it down, Your Honor, because I don't think that's what the temporary order said. It said it was talking about public web pages and Facebook pages. It's no longer public, Your Honor. And, I mean, I think at this point we're now going into First Amendment issues here.
No, we're not.
Please don't interrupt me. But point being is, he was following what the temporary order said. Public postings. It is not a public posting. It is a private Facebook page. The public can't access it, to my knowledge. I've asked the detective to show me how he can access it, and if so, then we will remedy that issue.
May I interject, Your Honor?
Just a moment. All right, well...
If you look at the dates, look at the first page.
No, I can see the dates.
It says it went from public to closed on March 15th.
Mhm.
These posts are from February 5th and February 21st. These posts were up when the page was still public.
And they're still up now?
They're still up now. So
and are you able to look it up on your phone and show it to me, that these are still up there?
I'd have to go. A friend of mine is a member of his group, and he found them for me.
Okay, so this isn't public. Your friend was able to look this up because he's part of the group.
We're talking about cyberstalking here, and just in the last couple months, there was a big story about the Marines. I think they called it Marines United, and they had a private Facebook page where they were harassing female military Marines with nude pictures and memes and and it was private. It was a private group, but it was still cyber stalking. And once the private group became noticed, then these women had their violation of their privacy. Just because you have a private group doesn't mean you're still not cyber stalking.
Yeah.
And I would also add that these members could take that and put it on their page, and now it becomes public. The whole point of the cyber stalking is to prevent me from being harassed or intimidated. It doesn't matter if you're hiding behind it. And the respondent has been using fake names. He introduced himself as Richard Lee to me. I didn't know who he was, really, Reiners, and so he's hiding underneath these hidden identities and other pages. And just because it's that doesn't mean he hasn't been cyber stalking, and this is a clear violation of the order that existed.
Well, here's what the court's temporary ruling is on this. I would like more briefing regarding this issue if he's in a closed Facebook group and he thinks that he can continue this. It concerns me that your client isn't getting it, that this petitioner feels harassed and he is encouraging further harassing behavior by having a group where he complains and makes memes and does all these things. He's not getting it. It concerns me that the response to this protection order would not be to take everything down and move on. that concerns the court. So I think that based on the information that I have so far, that this is within the closed group, and I want to have more information on it. I'm not going to amend my order at this time to prohibit you from doing something within a closed group. However, with the caveat that it is extremely concerning to the court, and your right to do so may be future limited. There is not to be any sort of public postings about Mr. Moriwaki. I would consider old posts that were predated this order that continue to remain up as a continued harassment of him by their remaining there. So anything public that is being done towards the petitioner needs to be stopped. I think I'm trying to make myself very clear. Is it clear?
Well, I do have to ask, so is the court concluding that a private group is in fact a public posting?
No.
Okay.
I want further briefing on the issue for the full hearing. But at this time, anything that's public, anything that can be seen by anybody who comes along, I'm not saying members of a closed group, needs to be taken down so that I'm very, very, very clear. And it may be that I rule further once I consider the case law and the evidence here about First Amendment issues. But like I said, it's sort of the principle of the matter. You need to leave this man alone. He doesn't want anything to do with you. He wants you to stop harassing him. He feels threatened. He feels your speech is infringing on his personal right to be safe, and it has to stop. So I think that addresses the issues. I have copies of the order. I'm going to have Officer Roach come in here and bring the copies to each of you to sign. I need the respondent to fill out the respondent information form before he goes. And there's that one. Oh, next hearing. I was thinking about 30 days out. Do you feel like that's going to give you enough time to get more information from the prosecutor's office?
Let me have. Yes.
Okay, let me have that order back. Sorry, I didn't talk about the dates. May 23rd. How does that look? Okay, it's a Tuesday, 1 o'clock.
In the afternoon, Your Honor, 1 o'clock?
Yeah, 1 o'clock.
That's fine. I have court in the morning. That's fine. Yeah.
Okay. So, and that's going to be a status hearing. So, like I said, the respondent's presence is waived because he's represented by counsel only. There will just be a conference call. I just need you to call the court about 15 minutes prior to the hearing and indicate where we can conference in with you, but you don't need to appear in person. So hopefully that will be the least inconvenience. And at that time, we'll hear an update regarding the criminal charges and either continue the case or set the case for the full hearing.
Right.
At that time.
So typically if there is a setting for a full hearing, how much time is that after this phone call then?
We can discuss that. So it's flexible.
Right.
So I'll certainly take into consideration the needs of the parties and schedules of the parties, and so it would be helpful if your client, since your client's presence is waived, if you kind of have an idea of what his schedule it would be, and if there's any issues. We typically do these on Mondays and Tuesdays at 1 o'clock, and unless we need to set it at a special time. All right? Okay, I think that addresses everything. Any further questions? Anything else that I need to address? Okay, and so I set that status hearing, but that will be stricken, assuming that proof is filed, and I'm assuming that you'll help your client follow up with that?
Yes, Your Honor.
Okay.
Also, can we also advise the petitioner that anything he submits to the court needs to be also sent to us?
Yes, thank you. That is important. So he does have counsel. I think you've received a notice of appearance, so anything that you want to file with the court, just send a copy via mail to him. Sometimes, since we do have a lot of pro ses and this court is small, we often will facilitate by sending things out to make sure that the parties are ready for the hearing, but typically the court rules do require you to give it to the court and then give it to counsel. All right? All right, court will be in recess.
Howie. Can you hear the court?
Yes.
Okay, so you can hear now.
All right. Okay, so again, this is call number 12-17, and we are here for a status hearing. The reason that the court set the status hearing was because the respondent had originally requested a continuance to investigate the possibility of whether or not criminal charges were going to be filed stemming from some of the conduct involved in this case. Mr. Savani, have you been able to gather any additional information related to that?
Basically, yes and no. I reached out to the prosecutor again about a week and a half ago asking as to the status of the case, and he informed me that a decision has not been made, but that he would contact me as soon as a decision has been made as a matter of professional courtesy. Since that time, the prosecutor has not contacted me, so as a result of a lack of communication from them, I can only assume that a decision has not been made charge-wise. Additionally, I've not seen any indication of any charges online, so I'm only left to believe that a charging decision has not been made, and whether it be to charge or to decline, as to the lack of communication from the prosecutor.
All right, and is the prosecutor aware of the fact that there's pending civil litigation?
Yes. When I first reached out to him about a month ago, I made him aware of this pending case. That was before we initially appeared in person, Your Honor. And at that time, he thought a decision was being made quickly, but the lack of response has indicated apparently a decision has not been made quickly. So we're just kind of left here waiting to see what they have to say, but unfortunately I don't really have any more information as to a timeline from the prosecutor as other than any day now.
Okay. And so what is your position regarding going forward with this matter?
I think both myself and my client agree we would like to have one last stay for maybe about 4 weeks, and if we don't get a decision from the prosecutor at that point, then I think we probably will be proceeding shortly thereafter. But I think one more status conference meeting would be appropriate.
All right, and Mr. Morawaki, response?
Yes, Lydia, can I ask the counsel, if I just heard him correctly, he said he only contacted him a month ago prior to our court proceeding? Is that correct?
Well, that was the first time I contacted him, seeing if there was going to be an answer, and at that time he hadn't even looked at the file at that time, because then I contacted him again about a week and a half ago, and he said no decision had been made.
Okay. Yeah, I misunderstood your previous statement. You didn't say it a week and a half ago.
Well, it's always challenging on these telephone conference calls to hear thoroughly. All right, so Mr. Morawaki, he's asking for another status hearing 1 month from now to revisit the issue due to the fact that there may be criminal charges pending. And so do you have a position?
Yeah, I totally oppose it as my previous position. Again, this is a civil situation. I'm simply asking for a protection order, hopefully permanent. This is just to stop the cyber stalking, which the court has given me that free order. It's not, other than, I don't know what the criminal proceeding has to do with it, whether that goes on or not. The case is closed. The Bainbridge Island Police Department has already submitted their statements, 2 of them, to the prosecutor, as counsel knows. That was 2 months ago or more. So, again, this is sort of like saying the judicial system can't walk and chew gum at the same time. They're 2 totally different situations. I'm just asking for permanent protection from the end of the cyber stalking and all the other harassment. I want a buffer zone and such, and the prosecutor could decide tomorrow, he could decide in 6 months. That's really irrelevant to the protection order. He's been in violation of the cyber stalking statute, as you have determined, with the award of the temporary protection order. And so there's really nothing new that could be done from a criminal proceeding. the criminal proceeding would just be the adjudication of the prosecutor saying you have violated the law. You've made a determination that that's happened because of the evidence I presented just on its face, that you did violate the cyber-stalking statute. So I'm just asking for my personal protection. And I don't see why the stay in another stay is necessary. And then I'll further add that this is just continuing more, not just the Harrison issue, but I'm having to live this every time I have to come to one of these meetings. I just need closure on this. It's really frustrating. It's dominating all my life, a lot of my time. It's stressing me out. And that anxiety just has to come to an end. It would be the relief of having the permanent order. I could be done with it.
All right. I understand your position. I think the issue here is that he has a Fifth Amendment right to remain silent about any potential criminal allegations against him if those are going to be going forward, and whether to know whether or not those are going to be going forward, in order to determine whether or not his client should provide statements about this incident or not. And so the court often runs into this situation where we have a parallel matters going on, a civil matter where you're seeking to get a civil order against somebody, but then they are potentially facing criminal sanctions out of the same exact conduct, and feel concerned about responding to it under oath in a court where things are being recorded and whether or not that should be done. So the court understands the position of the petitioner. However, I feel that I can't force the respondent to go forward at this point without further information. I am going to grant the request for the continuance to June 20th at 1 p.m. This is going to be, again, a status conference. I think the position is reasonable. If there's no criminal charges filed by that time, then the the respondent would be in a position of being willing to go forward at that time, and that's what the court would be inclined to do. And then if there is criminal charges filed by that time, then there will be more information for the court about going forward. The concerns about the petitioner have are mitigated by the fact that I'm continuing the temporary order in all of its terms through the next court hearing. So that will remain, and in all of the terms that were previously listed. So I'm taking a look at the temporary order. Just a moment, I need to get to the right place. All right, so the temporary order that is continued is the one that was issued on 4/24/2017. The terms of the order are not to have any contact with the respondent, may not have any contact with the petitioner, may not keep him under surveillance, is excluded from his residence or workplace and any public events where the petitioner is present. He must stay away from his 300 feet away from his residence, workplace, any public events where he may be present, and he has to remove public web pages, Facebook page with the petitioner's name. And he is to surrender weapons, which he has already done. Now, I know there was a motion that was submitted by the petitioner, one to clarify the foot amount, which the court denied based on the fact that would impede his ability to reside in his home and ingress and egress to his home. And then the other one was submitted basically requesting that any mention of Mr. Moriwaki's name be removed from his Facebook page. And I can understand the desire on the fact of the petitioner of wanting to have his name removed. However, I don't think that was exactly the court's intention. At the time, there was a Facebook page named Not Clarence Moriwaki, and there was a bunch of information that was posted on there that the court granted the temporary order based on, and that was more harassing in nature. And the information that was submitted by the petitioner was sort of old posts that were did not appear to be harassing in any way. It was just referenced Mr. Moriwaki's name, and I don't think that was what the court's intent was to that the respondent had to sanitize any listed name of Mr. Moriwaki. Does that make sense, Mr. Moriwaki?
Yeah. Yes, I would strongly disagree on that point, but before you go on that, could I get clarification? The first motion is clarification on the 300-foot border, and I just want to make sure that all of us agree on where that border is, as given by the map I submitted.
I'm not, listen, this is something that goes into law enforcement, and it has to be very simple. This is not something where the court can attach a map and indicate you can go here and you can't go there. It's not the court's discretion to, do this kind of a thing. This has to be an easily ascertainable standard that law enforcement can understand. They are not going to have access to maps. They are not going to be able to look at this information that you've provided. And so the amount of relief that you're going to be able to get here is somewhat limited, Mr. Moriwaki. Do you understand?
I understand that. What I presented was, this was what the council presented, because they, of course, wanted the minimum amount of barrier possible, so they picked the furthest most corner of my property, of which I can't even access. It's not even, it's behind the dumpsters and all that.
This was just a rough discussion at the time. It was not, the court does not take maps and draw boundary lines and make this kind of a determination. So I think what you're asking for is not something that you're going to get as a part of this court order or any court order. It's going to be a foot determination from the House workplace. And unfortunately, there's some perhaps lack of clarity in your mind about that, but I'm not willing to go into a place where we're going to get out maps and measure things with GPS and draw boundary lines.
Well, that's disappointing. So, according to that decision, the petitioner could theoretically be in Winslow Green, because I demonstrated that with the map. He's within 200 feet of my place.
He's not to surveil you or have any contact with you. If he was standing on the edge of Winslow Green where you live, and it was determined that his behavior was surveilling you, that's still a violation of this order.
All right, good enough. Fair enough. Okay, on the second part, Your Honor, the whole point of the cyberstalking statute is the intent to harass, intimidate, torment, embarrass, and all the rest. And the state is due to that is pushing me to try to kowtow to a position that he wants me to agree to, of which I do not agree with. And when he took down those posts, he took them down the same day that he closed the page and made it private. These posts, some of those were almost at the same time. So being of age or older is irrelevant. It's the content of what he's saying about me. This is attacking my character. He's trying to say that I cannot, and somehow refuse to do what he wishes. All that kind of behavior is, in its definition, stalking and harassment. So that's what those posts are. And whether it, and so that's like,
if they are violations of the court's order, then your remedy is to contact law enforcement and report them as a violation. And the position of the respondent is that they're not violations. And so these are some of the issues that are going to be discussed in more detail at the full hearing. But at this point, I'm not seeing that there's any information that's so egregious that the court feels a need to take action beyond the temporary order that's already been issued.
And, Your Honor, this issue has also been addressed already with a detective. I was contacted before the prior hearing about this very issue, and nothing came of it. The detective was in agreement with me that it was in compliance with the court order. And this, again, was discussed at the last hearing. And so this is now the third time that the petitioner has brought up this issue, and it's getting quite redundant.
Okay. Well, I've explained and clarified. I'm not issuing sanctions as requested by respondent. I think that it's sometimes confusing to people who are going through this process representing themselves as to where the boundaries of the court order lie. And Mr. Morwaki is attempting to present his case, and I have indicated at the last hearing and today that these issues are deferred for the full order hearing. So I think we've addressed all the issues here today. We will have another status conference on this matter on June 20th at 1 p.m. Again, parties may call in or appear in person. It's up to the parties. I am going to need the respondent to sign a copy of this order. Counsel, did you want did he want to come to the court to sign that order, or is he going to sign that through you and send it back to the court?
If you can have Madam Clerk email it to me, and I can then have my client sign it, and I can send it back to the court, if that works for you, Your Honor.
Okay. Well, we will do that. All right. Anything further?
I just wanted to confirm to make sure there's no confusion. So June 20th is going to be a status conference meeting, just updating as to whether or not there are criminal charges being filed, and based off of that, we may be setting it for a full-blown hearing shortly thereafter, correct?
Correct.
Okay, just want to make sure. Okay, thank you.
So please re-clarify that. I originally heard you, Your Honor, say the status hearing on June 20th would be if there is any kind of information about any kind of criminal charges pending and or proceeding, but we will continue from that point, because this could go on for a year if they don't do anything. I mean, there has to be at least some point where this court has to take action on the civil matter.
And we have addressed that. My client has indicated to me that if a decision has not been made by the 20th, currently he's inclined to probably proceed shortly thereafter. So my guess is if a charging decision hasn't been made by the 20th, I suspect we'll probably be setting for a hearing in early June, a couple weeks later. That's my guess.
You mean early July?
That's what I meant. My apologies. Yes.
So I just want to make that clear that is what your client is saying he would do, that if there is no criminal charges and or proceedings by June 20th, then we can proceed with this civil matter of the protection orders.
No charges. If there are charges, then that's going to be a different issue.
Correct. We take one motion at a time. I understand that you want this resolved quickly, but unfortunately, certain civil litigation takes longer than one would necessarily want, and there are legal reasons for that, and the court has iterated those legal reasons for granting the request for the continuance, which is only the second request for continuance. It's reasonable in nature, and so we're going to proceed that way. All right, so June 20th at 1 p.m., you may call in or you may appear by telephone, and then we'll address what will be happening next at that time.
Thank you very much, Your Honor.
Your Honor, just for my clarification again, if there are no charges at that point, there's nothing happening then, what I heard from counsel, then they will have, the client said that he would move forward with a full protection order hearing in early July.
That's what he anticipates his position to be, yes.
All right.
Okay. All right. So we will send copies of this to everybody. Do we have Mr. Morwaki's email?
Yeah.
I believe we probably do. If not, the clerk will give you a call back.
Yeah, this is my name at Gmail.
Okay. Who is the attorney? Yeah. All right. That'll conclude this matter.
Thank you very much, Your Honor.
Thank you.
Thank you.